Good evening, everybody. Thank you for your technical patience as we deal with a few logistical challenges in our hybrid era. I'm John Pollock. If you can't see me, that's all right. You don't have to. If you can see Ada's PowerPoint, that's much more interesting to look at. So please focus on that. I'm one of the co-organizers of the History of Material Texts. You'll hear from other co-organizer, Jerry Singerman, momentarily, and then our speaker. I'm only going to preempt our wonderful presentation tonight very briefly, and I'm sorry to report in a somber fashion, because I would like to make an announcement that some of you may have heard already, but others in our material text community might not have. It's with very profound sorrow that we announced the loss of Scott Enderle, digital humanities specialist here at the Penn Libraries, Penn English PhD, and former Brisdell Schoenberg Fellow in the History of Material Texts. Our friend and colleague Scott passed away last week. We are all shocked and saddened by this tragic loss. I hope you'll indulge me in a very brief reminiscence of Scott's many roles in our material text community. His graduate work in English focused on the 18th century novel and copyright. Part of that work is featured in a wonderful 2016 article in PMLA entitled Common Knowledge, Epistemology and the Beginnings of Copyright Law. A short time into his graduate student career at Penn, Scott came to work in the library. That was the pre-renovated Kislak Center, just called then the Rare Book and Manuscript Library. Actually, he got one of the toughest assignments we've ever given, deep in the library's basement. We had just received the gift of the Gotham bookmark collection, a gift that consisted of dozens of pallets packed full of hundreds of boxes delivered to our offsite facility in tractor trailers. How to make sense of this near chaos? Scott became a kind of project manager without title, facing down the scores of boxes, the thousands of books, pamphlets, magazines, poetry chapbooks, flyers. His organizational efforts were the first step in the long road that turned the Gotham into a usable and extraordinary collection. Scott was the graduate fellow for this seminar in 2010-11. And as part of that assignment, he helped us run the seminar during a very, very challenging year of renovations. He did it as he did everything, with his easy, kind demeanor, with calm competence, and always with care and with commitment. After his return to Penn from teaching at Skidmore, Scott became a leader in our emerging digital humanities community. He's been a part of so many projects and discussions that it would be foolhardy to try to name them all, but I will just mention Zach Lesser's Shakespeare Census, a wonderful project, the Playbills project that Scott helped his advisor Michael Gamer develop and which is well underway, and a final one that will be a visual memorial for Scott for this entire group. Scott built the website and the back-end database that are pennmaterialtexts.org. So we send our deepest sympathies to Scott's wife, Rachel, his son, James, and all of their family. In our sadness, we honor Scott's spirit, his true kindness, and his work. Thank you very much.
At Ada's computer right now is Eileen Malcolm, who is this year's Brisdell Schoenberg Fellow. Eileen really keeps us running and efficient. And Eileen is also the keeper of the sign-up sheet. So please, everybody, a sign-up sheet is going around. In the past, they were somewhat voluntary. If you didn't sign up, because you didn't want to, that was okay. But now in COVID times, it really is a requirement that everybody sign up so that we have contact tracing information. if you are not from Penn or if you're not on the listserv, please be sure to add your email address when you sign up. Also, if you are here and you're not on the listserv and want to be on the listserv, add your email address and just add a note that you'd like to be on the listserv. Okay, before we start, for those of us in the room, everything is as usual. For those people who are Zooming who may or may not be able to hear me, not sure. What we know is that the questions from the room will not be audible or very audible on Zoom. So Ada will be repeating them and digesting them. The people who are Zooming, protocol for asking questions is protocol we've all gotten way too used to in the past year and a half. It's either enter a question in chat or use the raise hand function, and Island will communicate the question to the group. Housekeeping task done with, on to tonight's speaker. So 2016 was really something of an annus mirabilis for Penn medievalists. For it was in that year that Sarah Guerin came to the Department of the History of Art. Mary Chandler Caldwell joined the Department of Music. Raise your hand. And this evening's speaker, Ada Kuskowski, arrived in the History Department to fill a crucial and really too long vacant position in European medieval history. Now, Ada came to us via a southern route because immediately before Penn, she had held the Jeremy Buchanan Adams Centennial Professorship in Medieval History at Southern Methodist University. But like the two other colleagues just mentioned, she originally hails from a place somewhere north of here. She took her first degree at McGill, where she studied history, and then stayed on there to take further degrees in common law and civil law. Somewhere along the way to qualifying as a lawyer, this is my own reading of this, I really haven't checked with Ada, but somewhere along the way she seems to have had an epiphany and came to the realization that the best use of a legal degree was not in the service of some soulless big city law firm, that's my classification, but rather in the pursuit of further knowledge of the Middle Ages. It's an epiphany, if such it was, that led her to Cornell, where she took her PhD under the direction of Paul Hyam. Ada has held fellowships from the Quebec Research Center of Private and Comparative Law, from the NYU School of Law, where she was the Galli Fellow in Legal History, and from the University of Wisconsin School of Law, where she was a postdoctoral fellow in law and society. This semester, she's a fellow here at Penn at the Katz Center for Advanced Judaic Studies, where the year's topic is Rethinking Pre-Modern Jewish Legal Cultures. Ada's list of talks and conference presentations is a long one, but I would be remiss were I not to mention that she's the only person I have knowingly met to speak at the annual meeting of the Baronial Order of the Magna Carta, which took place in 2018, and of course here in Philadelphia at the Union League. In organizing this semester's schedule for the workshop, we've asked several of our speakers ponder in particular the usefulness of thinking about the category and reality of foundational documents, those texts that helped create or shape institutions and practices, or at the very least, those texts that were imagined to have done so. Now, it's not a thread that will be visible in every presentation this semester, though in the weeks to come, we'll be hearing about the founding charters of Tibetan Buddhist monasteries, for example, or about how in the 19th century, the materials produced by the American Anti-Slavery Society not only helped to galvanize abolitionist energies, but in some sense helped to create the sense of a modern mass market in this country. It seemed clear then that this semester was also the one during which we would finally make good on our longstanding intention to ask Ada Kuskowski to present on material drawn from her book project, Vernacular Law, Writing, and the Reinvention of Customary Law in Medieval France, wherein she questions the usefulness of the notion of the foundational document where medieval law is concerned. So it's my great pleasure now to step out of the way and to give the floor over to Ada.
Thank you, Jerry, for that introduction. It never occurred to me that there was so much humor in my CV. I'm going to see it differently from now on and find a lot more joy in touching it up occasionally.
I had to dig deep for that.
All questions about the Baronial Society for Magna Carta will be at the end of today. So thank you, Jerry, Zach, and John for the invitation to speak today, and to Island for helping out with all of the technical issues that we've had. And especially thank you all for being here, either in spirit on Zoom or in person in the room. So when I heard that the theme was foundational documents, I thought, oh, how perfect. I'm a legal historian working on the Middle Ages, and a large amount of the history of law is written and thought of as the history of important texts or important legislation. But then I got to thinking about the term. So what exactly is a foundational document, or what makes a document foundational? So I'm going to take a moment to muse on the idea of foundational documents, because I think it'll provide an important perspective on my topic for today, which is actually medieval customary law, a legal culture or practice, that did not primarily turn around what we might conventionally think of as foundational documents. And here you have an image meant to whet your appetite, from a 13th century manuscript of a French text of customary law. And you can see it's part of a text that treats what you do when you catch a malfeasor in flagrante, so in the middle of the act of committing a wrong. Here you can see him holding his victim by the eye socket, and the flesh is being sliced open, so it seems to be a successful crime, except he can't escape the long arm of the law, quite literally. So I'll come back to these medieval texts in a moment, but for a few minutes, I want to come back to this question of what exactly is a foundational document. So I asked a very famous scholar, to be sure, who was sure to have an answer, and the great scholar, Google, informed me that the Magna Carta, the Declaration of Independence, the Constitution, the Bill of Rights were all foundational documents. And you can see the search. I just searched foundational document. So Google correctly identified me as a modern person in America. And all I think it kind of shows, sorry, I'm a little out of breath. I think it also shows that there's a bit of a pattern in this idea of foundational documents. In terms of type, they're often governing documents or legislation. They're authoritative in the sense of being related to or backed by a state authority. They are each in some way seen as foundations of American democracy, so the ideals of the nation. And incidentally or coincidentally, they're all written on parchment, so animal skin. That Magna Carta is on the list is interesting, I think, for the nature of foundational documents. When it was first signed in 1215, it was essentially a royal charter granting rights and liberties that largely pertained to the upper class, signed by King John because of extreme political pressure. The British Library has a whole spread on Magna Carta, and one of the passages suggests something, I think, about the puzzle of foundational documents. So the British Library explains, although nearly a third of the text was deleted or substantially rewritten within 10 years, and almost all the clauses have been repealed in modern times, Magna Carta remains a cornerstone of the British Constitution. So one might ask, why? Why is this almost completely repealed legislation a foundational document? It can't be about the integrity of the text itself. Something else is going on, something more important. Most famously today, the 39th clause gave all, quote, free men, so not all people, but free men, the right to justice and a fair trial. And some of these cornerstone principles are echoed in the United States Bill of Rights, giving it a place on the list that we just saw. So we can look to any number of characteristics that are common to foundational documents. We can look at authorship, the source of the document, and the nature of the source's authority. Often, it does seem to be legislation approved and issued by a state authority. We can look at how much it's cited, how much it has a presence in popular consciousness, how much it reflects a vision of political ideals, how much it transcends time and space, and somehow captures the imagination, or is reinterpreted to capture the imagination long after the initial context and purpose and even content of the text have faded away. We can look to many things, but I think that one key factor is an attitude to the idea of text itself, a belief in the importance of not the text itself, but in the tradition of the text. The idea that at the beginning was the word, and the word was written, and the written word was not so much passed down, but continued to be taken up by successive generations to use the past for contemporary meaning. So when I heard the theme, I thought it could provide a lens onto customary law in the Middle Ages and vice versa, because many of the aspects just described fitted so well, but without the foundational text as a gravitational force. So today I will focus on a set of texts written in the 13th century in northern France called the Customary. And they're called that because they describe legal customs, so the ideas, practices, rules, and procedures of the lay courts, and lay courts as opposed to church courts. And I should note that I use the term France, but France is really constantly changing in this period. So you have some maps that you probably can't see that well that show the changing nature of what's, of the polity between the 12th and the 13th century. So I focus on the first, or the early Customary, because they provide insight into custom at a key moment when it was first conceptualized in writing, meaning first turned into a body of rules that was written and could be studied and circulated. I should note that custom has a general meaning of convention, tradition, or usage, but it also has a meaning of law, where definitions can vary, but it generally designates a usage established by long continuance to have the force of law. So it's a type of legal rule formed not by legislative act, but by practice. And then there's something that makes it obligatory. Sorry, I'm having a bit of trouble. So what was I saying? Oh, right. So I was describing the meaning of custom, being a type of legal rule formed not by legislative act, but by practice. And then there's something that makes it obligatory. And medieval jurists love to debate what the special ingredient was that turned what we generally do into what we have to do. Does it become obligatory by the lapse of time? Does it become obligatory by the consent of the people? Does it become obligatory because nobody does anything to the contrary? If it was time, how much time? Or maybe it was the number of times and not the amount of time that created a custom. In any case, practically, legal practice in the courts of northern France turned around a generalized notion of custom. This means that allegations of the parties made almost exclusive appeal to the notion of custom, so coutume or consuetudo, as the relevant form of applicable law. So you find statements like, according to custom, murder is a capital crime, or it is the custom that the baron is judged by his peers, or it is the custom that inheritance should be partitioned in the following ways, or it is the custom that this is the procedure to follow when somebody wrongfully takes your land, or this is the custom when buried treasure is found, or this is the custom on how to properly punish a horse thief, which here you have images of the murderer and the horse thief being caught. And this was true even at the highest level. So in the Parliament of Paris, which started to keep official records mid-13th century, the records generally do not cite legislation or court cases or books, but they cite custom, which you're probably starting to wonder, well, how did they know where this custom came from? That's a great question. Largely, the sources don't explain where they got it from. They're just all these statements about what it is. And until the coutumier, there was no one source that answered that question. So it's also important to note about the coutumier that they're not like modern codes. So they're not legislation by kings or barons or counts. It's custom that's binding, not text. So they don't contain an official law that's meant to be applied and enforced. They're more pedagogical texts that package and describe custom so it can be known and understood. Scholars mostly discuss the writing of custom in the coutumier and similar texts as part of a shift from orality to written record, famous through the pioneering work of Michael Clancy. In terms of custom being written in law books, the process is often described as transcription. So where people just wrote down what they saw as though it was an obvious thing to do. Scholars of France tend to talk about it as crystallization, as though custom hardened into text by some sort of natural geological process without human intervention, while others talk about this setting in writing as though a copyist kind of faithfully transcribed all dispute resolution practices into a text whose goal was to make these practices fixed and unchanging. I think the Northern French coutumier have some unique features that allow us to tell a different story, one that doesn't make customary law into yet another aspect of the medieval primitive. So backward looking, rote, unthinking, a community reflex rather than thoughtful action, traditional rather than innovative. The coutumier are not only, or even the first text to write custom, but the group shows, I think, that to write customary law was not just a setting in writing, but a form of composition, and the result of individual innovation on the part of each author, of each text, and even each manuscript. So first, almost the entire group of 11 texts, listed there, was composed in the vernacular rather than in Latin, which was the traditional, Latin being, of course, the traditional writing, language of writing for law, power, authority, university learning. And only 2 of these weren't written originally in French, but those that weren't were translated very soon after. So unlike the majority of previous legal writing, the audience is not the scholar, but the layman. And also the coutumier were written at roughly a similar time for regions geographically proximate and with relatively similar politics and culture. This distinguishes the coutumier from Latin law books that describe the laws and customs of the royal courts of England, and from vernacular siete partidas composed for Alfonso IX of Castile, and even the vernacular Saxon Spiegel, translated as Mirror of the Saxons. So instead of offering one representative text for a specific time and place that makes it look like there is one known obvious custom, the coutumier of Northern France provide a variety of approaches and perspectives at a similar time and similar place. And because of this, they invite a different perspective on the formative moment when customary law was first shaped into written text. They show that despite overlapping elements, customary law could be imagined in different ways in roughly similar contexts. In other words, it could be written in many ways. In fact, it could not be simply transcribed, it had to be composed. And each act of composition was an act of creation, a unique vision of what customary law was. This is the best picture I have of this text. This is probably best captured in the words of Pierre de Fontaine, who wrote his coutumier, generally referred to as the Conseil, around 1253. So Pierre wrote this Conseil, so council, in response to the plea of an unnamed friend who wanted such a text for his son. And in the preface, Pierre wrote, no one before me ever undertook this thing such that I have a model. So this is a pretty startling statement of novelty and originality, and it places law, notably unsophisticated, not university law, alongside other medieval fields that Patricia Ingham described as valuing novelty. This young man was to succeed his father and govern his lands. Upon inheriting, he would have to become a legal actor. He would have to provide justice to his subjects, keep his lands according to the appropriate laws and customs, likely represent himself in court, provide good advice to his friends. So he wanted his son to be able to study the laws, customs, and practices of the lay courts of Vermandois. It's a region just northeast of Paris between Flanders and Champagne. But there was no obvious place to gain this knowledge, so Pierre had to invent one. And it's not so much that there was no writing at all in terms of the secular courts, but that this was a formative moment in the expanding use of writing and the addition of new written genres. And Pierre saw himself as a pioneer in that regard. So there was certainly writing before the Coutumier. People at Material Texts might all be familiar with texts of this form. So they were records that were documentary, charters involving individual transactions between private parties. Here, though, the diploma and the letter patent is a transaction between a king or an emperor, between a subject. But in any case, they're individual transactions, what you might call kind of mundane records of everyday life rather than bodies of rules. Oh, yes. And I have these two, which are kind of more private documents, but the top one is still granted by Louis VII. And the bottom one is a charter reflecting a dowry given by parents to their daughter. Dowry is a very common topic in the Coutumier. Anyway, okay, so there are written documents, but there aren't written bodies of rules. I also want to note before continuing that the Coutumier were not isolated from other intellectual currents. So they emerged as part of the general wave of interest and a real kind of effervescence in the field of law that began at the end of the 11th century and continued throughout the 12th and 13th. And the chief representatives of this effervescence are normally the Roman law and canon law that was studied at universities, and the intellectual cultures surrounding these were one of foundational texts or texts par excellence. So here's some images from Philadelphia and also from our collection. First, of course, there's the Corpus Iuris Civilis, written in the 6th century, a codification under the Emperor Justinian that was not actually terribly important in the history of European law until the late 11th century, when it became the subject of lectures and interpretation, and became the basis of university legal studies. And sort of very differently from today, you didn't go to university to study actual law. That was used in practice. You went to university to study Roman law and think through it once you left the university. Yes, and the Roman law was extremely influential on legal culture, but it was not a law to be formally applied in any court. It certainly didn't have to be, but the graduates, university graduates disseminated it, and it had a very transformative impact on legal ideas. As you can see, it became the subject of many glosses, and the famous one is by Accursius, and his gloss served as kind of a reference, at least until the 17th century, for studying Roman law. But you can see here the culture of the foundational text and the text. And soon after Roman law was, people say, rediscovered or renewed interest, soon after that, we get Gratian's Decretum, a great synthesis of church law composed over time, somewhere between 1120 and 1150. And though it was never officially promulgated, the Decretum quickly became the standard textbook for studying canon law again, at university. I like the image on the top left because it shows different layers of glosses. The inside gloss is by Johannes Teutonicus, published around 1215, and the one around it is by Bartholomew of Brescia. That one came out a little bit about 30 years later, and it takes account the legislative act of Gregory IX, which you can see on the right side in the middle. So Gregory IX had a famous jurist named Raymond of Pignefort compose kind of an updated version of canon law. It was meant to displace the Decretum. It didn't quite do that, but it did become fundamental, and we'll be coming back to it a little bit later. And quickly itself became the subject of glosses, as you can see here. And the reason I have the bottom image on the left is just to say that actually many manuscripts of canon law have very, very beautiful images, just not the ones I kind of chose to show for today. Okay, so, and I do want to note that both Roman law and canon law had different forms, right? There were summae, there were texts that didn't have the text in the middle, but I think this captures the place of the, you might say, foundational text in the intellectual culture of the university, of Roman law and canon law. And this is something that really separates it from the customary law of the lay courts. So the Coutumiers were not dissociated from any of this, and that's important. In fact, several of them quote some of the Corpus Iuris, Justinian's Corpus Iuris, or the canon law. And in fact, some scholars see the Coutumiers as attempts to give customary law some of the trappings of Roman and canon law. Failed, of course. It failed because they can't come near that sort of sophistication, granularity, precision, extensive treatment of subject. So they're seen as attempting, but not being able to replicate kind of the forms of thought at the universities. But I think there's a reason why someone like Pierre de Fontaine, who knew enough about Roman law to use large block quotations in his text, though those were in the vernacular and without proper citation to go back to the original source, he used the Roman law, but still thought of himself as an innovator. So he's well aware, and he's a fan of Roman law, but nonetheless describes himself as writing something completely new, something with no model. So this was something he was aware of, but it was not the model for what he was doing. And just to compare, right, the Coutumiers could be very workaday documents that look very plain. They could be beautifully decorated, but none of them have an text in the middle, right? That just doesn't exist in the culture. I think some nice insight into customary law in practice on the cusp of writtenness, professionalization, and rule-based thinking is provided by a scene from one of the great bestsellers of the Middle Ages, animal fable known as the Roman de Renard, the first versions of which were composed near the end of the 12th century, so just before the Coutumiers. It's an animal fable about a fox who was a cheat and a scoundrel and always getting away with really bad things, from theft to rape. So Renard had raped the wolf's wife, and the wolf was seeking redress. So the wolf made a complaint to the royal court, and when it was done, the king, who was presiding, turned to the camel sitting next to him and asked for his advice on how to handle the case. Now, the camel was a very important guest. He was a friend of the Pope, a papal legate. He had studied law in Italy, the birthplace of university legal studies. In the camel's answer to the king, you can see the centrality of textual interpretation and in law thinking. But the answer itself is kind of made to sound ridiculous in the text. The learned camel gives his opinion in a bizarre combination of Latin, Italian, French, Provençal, and ultimately, we'll see in a moment, the answer itself is treated as irrelevant. And I think it nicely shows the difference between the intellectual cultures of canon law and customary law, between legal cultures based on texts and others not. So here's what he said. And what I've done here is replaced the French with English, but kept the other languages to kind of bring out that sense of ridiculousness. So here's what he said. Quare, my lord, maudite. We find written in the decretal legem on marriage violate. First, he must be examinar. If he cannot expurgar himself, you can torment him as you place, who has done a great wrong. Haec is my sentence, to lapidar la corpe, so to stone his body, or to burn this miscreant of la renarde. And by calling him la renarde, he transforms him into a woman. And this is a great medieval humor. Okay. So the camel was extremely learned, but he was a bit of a fool. He was also kind of out of place in the lay court, which was not the forum for this sort of thinking. And what happens next offers a nice illustration of the different legal cultures of custom. After hearing out the camel, the king turned to the peers at the court and asked them for a verdict, because Renard is a peer who gets to be tried by his peers. They then retreated for deliberations, which in a modern edition lasts for over 50 pages. It's very long. And the reason why I love this particular trial is that the trial records that we have barely give any information about deliberations at all. And when they do, it's these new records from the King's Court, and then it's extremely minimal. They didn't like recording deliberations. I can talk about why in question and answer if anyone's interested. So the mode of reasoning of the animals was very different from the camel, who began his legal opinion by citing the textual authority and how to deal with the issue based on that text. The peers, on the other hand, were concerned with how rape was dealt with in secular courts, and the first opinion voiced explained what the proper usage of the court was about proof in these cases. The discussion continued with the sorts of precedent, the animals continued their discussion by talking about the sorts of precedents that might result depending on what they decided to do. And different animals fell into different camps depending on how they understood the nature of justice. So some argued for retributive justice, and they wanted to see Renard punished. Others highlighted procedural justice, placing the process above what was clearly to be substantive justice, above what they clearly viewed as substantive justice. Others focused on restorative justice, on compensation of the wolf for the harm that was done to him, his family, and his honor. That's right, him. But in all of the 50 pages, they never once referred to the camel's learned opinion. They didn't refer to any text at all. There was underlying their discussion an idea of how we normally do things, but it was not followed by rote repetition of things that had been done in the past, but it was weighed against other considerations. So customary law here was not, in fact, a text, not a list of fixed rules that were applied to a set of facts, but a practice that happened in deliberation. So before the coutumier, how could you learn the various rules and procedures that anyone used, that people used in any court? Well, with a lot of effort and difficulty, you could assemble them together. So procedural manuals had been written already in the 12th century for the church courts. They established and demystified the legal process, and these complemented an already rather rich body of legal rules. But none of this existed for the lay courts. So Pierre's friend and his son, for whom the text was written, would have to attend court sessions, watch, observe, try to remember as much as they could. They could observe and listen to people who had attended court in the past. They might ask for advice from friends or administrators. They might familiarize themselves with the family's documents, if they had any, that affirmed their rights or transactions that had happened in the past. But ultimately, it would take a lot of time and effort to get a good handle on how to run a court, or how to navigate other courts, or how to give good legal advice. And for this reason, the father had implored Pierre, quote, so many times to compose a written text that his son could use to learn how to become a legal actor. And that, of course, is kind of a trope in the Middle Ages, right? The convincing the reluctant author to write a text. But it feels so real this time. I don't know, you can tell me. If what Pierre accomplished, compiling and systematizing disparate rules of custom into a body of coherent law, seems like a natural way to package customary law. So as simply as a corpus of rules, it's because Pierre and other coutumier authors gave it that form that's so familiar to us as how you write law today. So Pierre reminds us that it was no obvious thing to decide how to compose customary law or even make a body of rules out of it. And again, this was not a transcription of the obvious, but an intentional act by authors, 2 whose names we have, 8 who decided to remain unknown, to physically, substantively, and intellectually transform individual customs into knowable bodies of customary law that were placed in books and codices. So they created fundamental texts, but whose primary hallmark was multiplicity. They were multiple in the sense that each author composed significantly different texts with their own approaches to the subject, So some preferred to state rules. Some tied these rules to cases. Some used Roman law, some used canon law, some used one, the other, neither. Some describe a lot of verbal exchanges, while others don't. Some discuss some written documents, others never mention them, and so on. But there were also multiple in that the manuscript tradition of the Customary shows that written custom continued to be a living law, continuously adjusted and sometimes transformed in and through its rewriting. So mouvance or variants are well known to scholars of literature, but legal historians tend to acknowledge the variants of texts only to get rid of it, to decide on an original version, and to establish a critical edition. The Customary were written before an understanding of legal text as fixed predominated, and they invite us to think about how written texts were assimilated into a mostly oral legal culture. Scholars, from historians to legal scholars to anthropologists, associate oral custom with creativity and written custom with fixity and petrification. But what we see in the Customary is a new avenue for creativity, is that the written provides a new avenue for creativity. Each manuscript copy of the text, with its emendations, deletions, additions, shows not only creativity, but continued active thought. A practice that was still deliberative, but that this deliberation could keep taking place through written text. Oh, these are images of the Conseil de Coeur de Fontaine that I forgot to show. Oops, not yet, okay. We can see this, that's a later version of it, but we can see this in a 14th century version of Philippe de Beaumanoir's Customs of Beauvaisis, originally written in 1283. The 14th century abridged version sliced off the prologue, took away Beaumanoir's name from the text, removed all the passages that refer to geographical locations, so the Beauvaisis, and changed references to the account of Clermont to, quote, the sovereign. This abridged version then removed any information that permits the identification of the original text, its author, or geographic ambit. In other words, the abridged text took the customs of Beauvais, Clermont, outlined by Beaumanoir, and made them virtually placeless. So the text became a general work on law and governance. And we can see the changing conception of custom from territorialized rule to abstract norm here. And I think it really shows the extent to which a later copyist could change an earlier set of customs, not only with creativity, but also with deliberation to create something quite different and quite new. So the Customary are useful not only because they demonstrate customary norms, but because they're a gateway into the creative mentalities of written customary law. This creative mentality can be seen not only in the authorial choices involved in the composition of each text, not only in the manuscript tradition, but also in the relation between the Customary themselves, as writing a customary law went from, but in the relation between the Customary themselves at a time when the writing of customary law went from being groundbreaking, the time of Pierre, to a form of known legal literature, maybe even genre, with its own tradition. So unlike citation of Roman and canon law, which tends to be regarded as a reverent citation of authority, whether or not it's attributed, the practice of copying portions of one Customary text into another has been generally treated with some disdain, notions of intellectual hypocrisy and cultural deception. So words that tend to be used are plagiarism and shameless pillaging. While copying from texts of Roman and canon law is seen as aspiring to something better, an attempt to add sophisticated erudition, someone copying from a Customary was at best uninventive and at worst disingenuous, a thief of custom and identity. But I think in the practice of copying from one Customary into another, we can see something that was integral to customary law thinking, something that shows this continued creativity, thought, and choice that I've been talking about. And probably the best example of that, or one of the best, is the Établissement de Saint-Louis, originally composed around 1272, And it really shows the reuse and remix culture of the coutumier, so of written customary law. The text itself was kind of a cut and paste job. It begins with two ordinances that were collated with the customs of Touraine and Anjou, which was collated with the customs of Orléans, and into that were inserted citations to Roman law and to the decretals of Gregory IX that we saw just a little earlier. And I should note that the citations are not quotes, but citations to the original source, but they appear both in Latin and in French, kind of willy-nilly. The fact that we even called this text the Établissement de Saint-Louis, so établissement like ordinances, is the invention of a later manuscript tradition. It was originally described as the usages or customs of the provost of Paris, but in the late 13th or early 14th century, a manuscript added a prologue to the text, turning it into legislation issued by Louis IX around 1270 on the eve of Crusade. And people really believed that it was legislation by St. Louis until about the 19th century. So not only was the Établissement composed with chunks of earlier legal text, but then it also appeared in coutumier of various other regions, such as Brittany, Picardy, Hainaut, Flanders, and Artois. An abridged version pops up in Champagne, and this abridged version of the customs of Touraine, Anjou, Orléans held itself out to be the customs of France and of Champagne. So you might say that the author of the Coutumier d'Artois summarized this practice in his prologue when he said that he, quote, put those who treated this subject in his book, a little bit from all of them. True statement. Chunks of both Pierre's Conseil and the Établissement de Saint-Louis appear in this text, combined with various accounts of cases that the unknown author had seen himself. In fact, the author begins the text with a reflection on its innovative nature. As he noted, no one before me ever undertook such a thing, such that I have a model. If you're thinking, wait, what? That's the right reaction. So he took this directly from Pierre de Fontaine's text, along with other selections of text. No position of self vis-a-vis the source. And while it might be funny, it doesn't seem that truth of claim was especially important, but perhaps what was important was building on an earlier model. Pierre, in his text, did invite later readers to amend his text, and also being part of a professional community. Later, the Coutumier d'Artois was picked up by Jean Boutier in the later 14th century, and Jean copied several cases directly from the Coutumier d'Artois into his text, even repeating the author's claims of having seen them himself. So authors of coutumier in the manuscript tradition show an attitude to earlier text as foundation, as a sort of authority in the sense that they are merely reading them and incorporating them into later texts. But also they show an approach to that authority that was infinitely malleable. And that's truly important because that's not at all how customary law is normally seen. It's seen as a replication of the past. So what we see in the uses of text of customary law as a pool, so what we see in the coutumier is the texts of customary law being used as a pool of common customary legal knowledge, one that was textual but not grounded in a central text. There were no heroes, not yet. The custom of Paris gets made into a hero in the 16th century, but that's a different story. There were no symbolic foundational documents. At the same time, together, the coutumier were foundational documents. Through the 14th and 15th centuries, more continued to be written. And this is when we get the time of what scholars call the official coutumier. So, here we have still kind of an unofficial Philippe de Beaumanoir, 15th century. So the official coutumier. Soon after the 100 Years' War, Charles VII determined to reform custom in the aftermath of the war. He issued the Ordinance of Montiel-les-Tours in 1454 and ordered the official redaction of the customs of each region of France in order to, quote, eliminate variation and contradiction. So the culture I've been talking about is about to be snuffed out. But it would take about another 100 years or so. People were, regions were seemingly slow to get this done. But eventually, about 100 years later, the areas of France each have their own customs, and the 13th century were consulted in the making of several of these. And so here you have just some images of later texts from 15th century. And here you can see that they continue their life in print for a long time. They don't remain fixed, even in print. They're reissued and updated, but that happens now through official process. And so the Customary texts of custom were the textual foundation of French law until the Revolution, when they're replaced by the code. So the code is one law for all, rather than the multiplicity of custom that was confusing. Though the Customary continue a little longer in the colonies, where some of them lasted a little bit longer. So, and here's just note, also Roman law and canon law continues to be replicated too. So this is not a unique feature of customary law. Okay. So medieval customary law was replete with not one, but a multiplicity of foundational texts. But you might say that the foundational text is less a document and more a way of thinking about a document. It's kind of a cultural approach. It's less about authorial intention than about tradition, about what happens to the document later in history. It's about its staying power, continued references. Something about it generally or specifically remains meaningful as time passes, when the moment of creation and its context is no longer relevant, but it's still rife for reinterpretation, reinvention in a new context. And this aspect of foundational documents fits customary law very well. But it's also a cultural approach that turns kind of around a unitary text or a set group of text, where it's important and valued to have identifiable foundations. And that's where customary law kind of no longer fits the bill. So as a parting thought, not so much as a conclusion, but I was, just want to raise the question of whether instead of foundational documents, we should be talking about foundational practices, a series of acts and cultural assumptions that make certain texts foundational. Thank you.
Thank you so much. Floor is open.
I'm going to give it to Bill again.
Liliana?
Thank you so much. It was wonderful. When listening to the difference that you have explained between the written and oral and the exchange and the process over the fixed situation and so on and so forth, I thought all the time about the stress on the vernacular language versus the Latin. And looking at the map, the different regions, and looking at the change of the shape of France, I wonder whether these texts in process importation did something else as well, shape the French language.
Did something else as well?
But shape the French language that everybody in different countries could understand. This I'm now being parallel to Germany, where certain events and measures and texts created the German language. Now I wonder whether these customary books, because they quoted the very process, they went from region to region, created also something that people could understand in different regions, and was then put down as a language that more than the people from one specific region could understand. In other words, were they helpful for the creation of modern things?
I don't know if I'm able to.
Try to briefly summarize.
Oh, sorry.
Since we are needing to digest questions, do try to keep questions simple.
So we'll find out whether I properly understood the question, which is whether these texts had a role to play in spreading the French language, spreading a uniform French language. And you know, what's interesting about them is that most of them, so these are the texts again from northern France, but most of them are written in Ile-de-France French, so the French kind of in the royal domain, or Picard, and those are the two kind of general vernaculars. So you don't see kind of more specific vernaculars. There is one text that's composed, that's copied in southern France. This is in the 14th century. And I'm not sure about the dialect of that one, but it is the case, and it's hard to tell, is it the copyists, or where is that language coming from? Is it the authors, is it the copyists? There's one new manuscript of Pierre de Fontaine that was unearthed by an auction house about 10 years ago, and they claim it's the earliest, but that claim is based on the fact that it's in Picard and not in Ile-de-France French. I'm not sure if that flies in the sense that that could have been the copyist. It could have, there's so many things that could have led to that other than it being the earliest. But I don't know. I'm not sure I'm able to make the leap to say that it's spread, that they spread, because the number, I mean, these are like other vernacular, they're not like huge numbers of texts. Some of them come in 2 manuscripts that we still have, some of them 20. But not like, you know, university manuscripts of Roman law, which, you know, we're talking about thousands. So, so I'm not sure if I'm able to make that claim. And also, in fact, I mean, it sounds like at least one, if not more, of the authors, Pierre de Fontaine certainly talks about this, the fact that, you know, he addresses both those who will see and hear the text. So not everybody would have been looking at the spelling. But I want to say yes, because I like to think they're very important. But I think in this matter, they may not have been quite fundamental until, you know, maybe those official versions and, you know, the printing press, etc. And there's just so many of them.
So you said that we could ask during question period, why did they not include the deliberations in most legal documents?
Oh.
Unlike,
so interestingly, well, I mean, I'm not sure they didn't want to, but they didn't do it. And I think part of that is a little bit of judicial flexibility, certainly when you're not writing things down. But one author, Philippe de Beaumanoir, talks about it explicitly, and he says, well, in the canon law courts, they keep great records. So of everything that happens in the trial. So you can explain what the deliberations were and then the judgment without fear. But in the lay courts, they don't keep detailed records of what everybody says in the trial. And so if you're explaining the deliberations, you're basically creating, you're basically leaving space for the parties to dispute the judgment based on the fact that the facts were written down wrong. So we don't do that in the lay courts, he says.
Maybe a follow-up question. Could you say then a little bit more about how these customers actually get used on the ground? That is, does a judge sit down in the middle of these cases and consult with them? Or can we know if the records of what actually happens in a given trial are so, well, deliberately spotty? How do these things actually get used? No.
We kind of both know a little and we don't know. So when they begin for the first part of their life, so say for around the second half of the 13th century, we can't know because, again, when the records say that they allege a custom, they don't say we got it from this book. So you can match a custom, right, in the book to something that's said in the court, but you can't prove any, you can prove correlation, but not causation. And the first references to the text that get to be made in court cases are at the, like, right in the last minute of the 13th century. They're both, I think there's 3, maybe 4 of them that I've been able to find, so it's not a huge amount. And they're all to the customs of Normandy, specifically, for whatever reason. And then there's some spotty occasions in the 14th century where you see the texts being cited in court, but not really. So they won't cite it in the way that you cite a university text, right? The author, if it exists, right? Book, chapter, right? Provision. But rather they'll say the text of the customs of Brittany, and you don't know anything about that text, or but those, again, are very rare, and I don't think it's the kind of practice of customary law to use text that way. So it doesn't mean that they're divorced from practice. And a number of them incorporate cases, and they show you how they extrapolate their rules from the cases. So they'll say this and this happened. This is what happened to the parties. In fact, I mean, sometimes their descriptions of cases are more descriptive than case records. And then they'll say, and so from this we can see that it is the custom that the elder daughter inherits the main house from the father if they're only daughters, and the other daughters get the remainder divided between them. So they show how they're creating rules from practice, but then are they being applied in practice? No, I don't think so. And I think that's part of the nature of how customary practice kind of was. You could learn from these texts, but you wouldn't be citing them in the same way as you would in an ecclesiastical court.
Oh, well, I was going to convey some questions in the chat. So if you could see, actually, if you focus that, but the first is Wendy Pepper, who asks, my sense is that the south of France was more dependent on written than oral law compared to the north. Do the coutumiers of the south work in an environment similar to what you described?
So yes, actually, I have a map ready, but now I don't know how to call it up, of the customary geography of France, which historically scholars have made a lot about the differences between southern and northern France. Did I repeat that question? That's right. Okay. So historically, they've made, so the north of France is referred to as the land of customary law, the pays de droit coutumier. Southern France is referred to as the land of written law, the pays de droit écrit. And that's certainly the case later. So France becomes very divided in terms, well, significantly divided in terms of the areas that refer a lot to Roman law versus in the south, versus the areas to the north that rely on customary law. But I don't think that's the case in the 13th century. So what happens in the south after the French take it over following the Albigensian Crusade is that Roman law becomes a way of defending local rights. But when they say Roman law, they don't mean the things happening in the university. They mean a tradition of Roman law that went through all of the early medieval kingdoms, ended up in Visigothic codes. And so what they're referring to is essentially the custom of Roman law as it developed in the south. So, you know, but it does become very important for regional identity, I think, in the 15th century and then on. And then there are these great debates amongst the jurists of France in really the 16th century onward about what is the soul of French law. Is it customary law or is it Roman law? And, you know, both of, you know, each kind of team has good reasons for seeing both throughout French history. So it becomes very important, but more in early modern times. It doesn't mean that there's no traces of that. There is a legislation, now I'm forgetting which Philip, maybe the third or the fourth, says that no written law will be referenced in areas of customary law. But I mean, it's simply not the case. So one of the things you can see in the Coutumier is a lot of use of Roman law and canon law. And you can see the concepts infiltrating the courts, just as in the South, they're not kind of, what's the word, treating Roman law faithfully, but they're using their own traditions, also writing customary texts, but that are perhaps more inflected. Yeah, no, I think I'm just going to end it there.
On the matter of regional identities and regional differences, what are the most extreme differences that you would get about a specific crime or practice, and how are they adjudicated? So is it pretty common that, you know, if you steal a cow in Brittany, the penalty is going to be the same as if you stole the cow in Poitou, or in one, you know, if you steal a cow, you need to make restitution by returning the cow, and another, if you steal a cow, you get your ears cut off. So, I mean, how much do they repeat one another, and how much do they really diverge from one another, and what is the mechanism for coming together? Which I guess you touched on at the end.
Yeah. I'm having trouble coming up with like the extreme examples.
Yeah.
There's certainly variation in terms of female inheritance, for instance, or how you divide property amongst children generally. But you know, I think it's really well captured by Philippe de Beaumanoir when he says, the customs in France are so different that you won't find one Castellany with the same customs as another. But once you learn the customs of one Castellany, it's really easy to learn the customs of another. And so I think it kind of indicates, you know, the differences are, you know, the punishment might be slightly different, but it's not that difficult to, you know, it's the differences I think are a lot less dramatic than it's made out to seem. And that passage by Beaumanoir, the first part is quoted everywhere, and the second part is quoted nowhere. It's kind of really emphasizing this idea of regionalism, which again becomes much more important later than. And this is not to say that there's no regional differences. There are, but I don't know if they saw law in the same kind of Enlightenment way as a reflection of identity and peculiarity quite yet, in any case. So,
I mean, one more follow-up question, if I can, and I'm working from vague memories, and I don't know whether this is the case in the French coutumier. Probably not. I certainly in some Spanish customers, in the Fueros de Cuenca, you know, I remember from years ago, it's very specified, you know, if a Christian steals a cow from a Christian, the penalty is this. If a Muslim steals a cow from a Christian, the penalty is that. If a Jew steals a cow from a Muslim, the penalty. And so it's very, very, it's actually very, very fragmented, but very dependent on the identity, the status, in this case, of course, the religion of the criminal and the victim. I mean, is there anything like that in the French coutumier?
So the question, to summarize, is in comparison to some of the Spanish fueros, like the Code of Cuenca, that talks about you know, this kind of punishment for a Muslim, this kind of punishment for a Christian, for various kinds of crimes. Is there kind of a similar awareness of cultural and regional identity in the same way? And, you know, actually, for me, that follows more the tradition of early medieval laws. So by early, I mean quite early. So 6th, 7th, 8th century laws post-Roman Empire that are probably best known for compensation tables. But if Burgundian is killed by a Roman, the Roman pays a much higher fine than if a Roman is killed by a Burgundian. And so there's a lot of ethnic differences there's a little bit of that in the Customary, but it's extremely minor, which, I don't think reflects reality as much as what they choose to write about. So you do have some provisions about weariness of strangers. Normandy notably has some provisions on Jews, but it doesn't, and I think partially these are more kind of regional texts, less urban, and those are really the fueros, a lot of them are very urban. So maybe, and also, in Spain, much more kind of diversity. And notably the Kutsumi don't talk that much about kind of punishment and compensation in the same ways. So a lot of them are about procedure, like what to do when a problem happens. There is something of, there are some substantive rules, but they don't give you a strong idea of punishment. In the images they do. So you can often see, there's a common imagery of kind of the hanged man in these texts, but yeah, I think that makes them a little bit different, but the fueros, of course, a lot of them are written kind of in the context of Reconquista, and they're creating rules for extremely diverse populations that have just come to be dominated by a new group. And these texts are a little bit different from that, that you might see the encroachment of royal power, but not so much. Yeah, so it looks a little bit different.
Okay. This is great, Ed. I mean, that was the most clear-headed explanation of such complicated stuff. I've never honestly understood any of this, and so that was an amazing explication. I'm so ignorant of this, it's hard, challenging, but I think we could take you up on your invocation of Clancy and this famous, thesis about orality and writing, and I wonder if you're willing to talk a little more about your, the way you kind of cope with that thesis, or I think you're really trying to rewrite it. And so I'm just curious, anything you have to say there about, you a second ago mentioned that Pierre, it sounds like explicitly talks about writing and orality in terms of how he sees his text being used, which is interesting. And it sounds like you're really trying to tell us that we're not in a situation of from X to Y, from orality to writing. That's the wrong-headed way of looking at this world. Is that one of your intentions here? Mm-hmm. Thank you so much.
So the question is about Michael Clancy and his description of the shift from orality to written record and how my arguments kind of fit into that or try to complement that. And I'm going to say try to complement because I'm a big fan of Michael Clancy, but I think, the idea of transitioning from orality to text is a little bit not nuanced. And I do think it's better to think of the increasing incorporation of written text into an oral culture until at some point, maybe we can talk about the switch flipping. I should also say that I'm not alone in this particular thought. So Simon Teuscher wrote a wonderful book called Lords' Rights and Peasant Stories. It's about the 14th century in Switzerland, but he does, he really investigates kind of witness testimony as a way of thinking about orality and text. But in terms of the coutumier, the part of Clancy that I think would like to nuance is this idea of a creative oral energy that gets stifled by written text. And that idea really got first written about by Michael Clancy, really taken up by Jack Goody, right? So taken up by anthropology. And so, I really try to argue for the dynamic vivacity of written customary law. And the other aspect that I guess didn't quite talk about that much today of Clancy that I would correct is this notion that he gets actually earlier from Fritz Kern, but this notion that any innovation in a customary law society happens under the guise of tradition. So in order for innovation to be palatable, you have to pretend that it's not, right? And I mean, I think just Pierre's words themselves kind of speak to that not being the case. But, you know, there's, I think, reasons why we like to think of customary law that way. Some of them are the battle between regions and the state. Others are the creation of the early modern state on the basis of a primordial remembered customary law. Others are imperialism and custom being the primitive and law being the modern. So, you know, I think all of that kind of inflects interpretation in really important ways, some of them visible, some of them less visible. But, you know, I don't, what Clancy did was reorient a lot of kind of stodgy legal, you know, writing. And he gave it a new life in a completely new context and really showed, right, that kind of culture matters for legal development. So I don't want to take any of that away, but I would nuance it in the ways I just said.
Thank you, that was really fascinating. I'm sort of filtering this a lot through like the early modern English. I think there's a lot that's really resonating with like the scholarship on institution. I have two questions that I think are related or may not. First, like the illustrations are really striking, but of course it's easier to illustrate someone getting caught like murdering someone than to illustrate like the equitable distribution of property among heirs or how you get married.
True.
And at least in the English context, when I think of regional differences in common law, it's like overwhelming on property law. So I wonder like what the balance is here, like criminal law, property stuff. And then the other question I have is about custom. You said like there's not much sense of like regional identity. So is there any material and means that is about custom that's not like law per se? Is there any sense of a connection at this point between the idea that law is defined by custom and that certain regions have particular customs that might be about like festivals or what you do when you have a new lord of the manor, those kind of things? Like, is there any of that material?
Not that I can remember, right? Not off the top of my head. It really is very much legal customs, at least these texts. It really is about, I mean, courts and dispute resolution and ideas about law. It really, really is. And it's interesting that that's not there. I mean, there's things that I would want or expect to be there that aren't there. One is, you know, more about ritual. If you find ritual, it's really kind of homage. You know, I would expect more about, because there's so many, in many of the texts, of verbal exchanges, but without kind of rhetorical training. So for instance, in a canon law text, you might find, I'm blanking on his name, but there's a 13th century canon law text where the author kind of trains the young canonist in unctuous speech, right? So kind of overpraising the judge and his intellect and so on, so you can get a good result. That kind of thing is not present in the Customary, which you would kind of think that it would be. In terms of diversity, you know, there's some that include kind of a peasant culture a bit more. So theft of pigs or things like that, rather than lords and their big pieces of land. But it really is kind of squarely legal in terms of intellectual framework. Crime is there, but it's not explained as much. Property, wow, yes, there is a lot of explanation, right? Crime, it's mostly in terms of jurisdiction, who gets to decide. So for instance, in France, they talk of high and low jurisdiction. High jurisdiction is the kind that can apply the death penalty. Low jurisdiction applies fines and breaks some arms. So, it's mostly about defining kind of who has what kind of jurisdiction rather than telling you, how to decide specifically the penalty for a specific crime. There is a lot of property. But there's also some family law. I mean, there's things that some of them shouldn't be there because they're a little bit ecclesiastical jurisdiction, but they kind of filter through these jurisdictions. Theoretically are extremely different and practically have a lot of overlap. Yeah. But it's true that property really, really dominates. Crime is there. It shows up, in cases you see kind of both, but I think property really drives a lot of interest in legal writing and the disputing process.
So when, if ever, do these things become studied in law school?
Wow. There's they don't. I mean, until about the 18th century. There's a very wonderful farce from the 16th century called the Farce of Master Patelin. And he's this country bumpkin lawyer. He makes fun of people who went to schools and they're reading, he knows books of law. They're like conjuring books. You just say things, incantations. He kind of makes fun of it. And, of course, it's the play is written by lawyers making fun of the type of person that he is. But the fact is that still in the 16th century, you go to school to study Roman or canon law, and then you go to court and suddenly you have to be an expert in customary law. And there's another farce, much less well known, called the Farce of the Old and New Digest. And this is kind of a play on the way they used to divide Justinian's digest in the Middle Ages. But in this farce, they're personified. The old digest has yellowed pages and people don't consult it that much anymore. And the new digest is shiny and white and so attractive. And they're debating between each other which one's better for about half the play. And then customary law walks in and says, nobody cares about either of you. And that's the 16th century. So I think it kind of shows this very strange, but maybe not strange, right? Just a different way of thinking about kind of learning ideas and what happens in practice. Definitely different from today.
One last question.
Right, yeah, I have a follow-up question about that actually, about the distinction between canon or Roman law happening in Latin and then customary law happening in vernacular, and whether this kind of customary law and that kind of attitude towards customary law ever found its way into the Latin kind of glosses on Roman texts, like whether there's ever a Latin discussion of customary law and its value in that context.
So yes, and so and here there were like regional differences in terms of university cultures. So in Italy, and maybe Anne will correct me if I'm wrong, but my understanding is that there was less attention paid to customary law in practice. But the French, so-called the French school, by the late 13th and into the 14th century, they are thinking about customary law connections to the stuff that they're doing. And so you will find that there's one of the texts that sometimes people include in the list of coutumiers, I don't, is called the Livre de Justice et de Paix, so the Book of Justice and Pleading. It's a translation of Justinian in French with cases inserted about like the butcher of Orléans and what happened to him and stuff like that. So it does produce kind of a vernacular literature to some extent, although that's probably the best representative of it. But some of the professors, but there's still an assumption of the cultural superiority of Roman law, and I think that's probably best captured by Professor Jacques de Révigny, professor at Orléans, who refers to laymen as rustici. And they're always talking about, what we normally do, but who cares about that? Because we have the superior Roman law. On the other side of things, there are translations of Roman law already from about 1230. So that's very early in translating university texts. That's around the time, I think, that the complete Bible was translated. And that's when you get the institutes translated, and the university texts are also translated throughout, I mean, both the canon law and the Roman law throughout the 13th century. And so I think, and it's hard to tell whether someone like Pierre de Fontaine has a translation, is translating it himself. So there's contact, but the intellectual milieux are very different. And you can see that in Philippe de Beaumanoir, who, when he talks about, I think it's the chapter on custom, but now I'm not remembering, maybe not, but he talks about how clerics speak so beautifully that nobody understands them even when they're speaking in French. And for that reason, he's choosing to write in the language that laymen can understand. So he explains his kind of vernacular choice that way. And it's interesting because his is by far the most sophisticated of any coutumier. It's enormous. It seems to be so inflected with university learning. He never quotes any Roman law or canon law, either by citation or by quotation at all. So I don't know, there's clearly mutual influence, but there's clearly an idea that they're just kind of different things for different spaces. I don't want to say it's necessarily acrimonious, but I think sometimes it is. Yeah. Thank you.
Well, thank you so much. This was really